Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're talking about ankle fracture verdicts, bimalleolar and trimalleolar fractures of the ankle in various accidents like car crashes, trip and falls, and other liability type incidents. So let's get into it. Now, to start off, we have to ask, what is a bimalleolar or trimalleolar fracture? Well, the easiest way to explain it is to look maybe at an image. So I could share my screen and show an image, and this is actually what it looks like. The lateral, there are different parts of the malleolus, right, which is the bone. There's the lateral, there's the medial, and then there's the posterior, as you see here. The posterior in the back, the medial in the middle, and the lateral on the side. And it's really like it's a very interesting area because there's like three different areas. You have your foot on the bottom, but then you have all these bones converging. So it's an area where if it gets injured, it's very vulnerable, it's very susceptible to injury. And then the only way to really fix it a lot of the time is to put in a plate with screws. So it's a very, involved. It's known as open reduction internal fixation. It's a very involved surgery. So it is a pretty bad injury. And here's another picture. Let me share my screen here and show another picture. So this one is this is actually a trial exhibit, I guess you could purchase. I just found this on Google, but you see the medial malleolus can be broken here, the posterior in the back, and then you have the lateral over here. And then of course the foot on the bottom. And then you have the tibia going up and then the fibula coming down, up and down, both of them. But the point is that if you have breaks in all three, the only real way is to do that open reduction internal fixation procedure. So let me look at some cases. I was reviewing some cases earlier. Let me open up the cases and show you. Basically, the cases that I found, I just sorted it by most recent. And the most recent one I found was actually this past summer out of Texas. And what happened here was, it was a December 1st, 2018 date of incident when the plaintiff, who was 33 years old, was walking across a driveway of a grocery store parking lot and was struck by a vehicle exiting the street. And so they filed a lawsuit, and the plaintiff alleged that the store should have had a stop sign, pavement markings, or a person directing traffic at the parking lot exit. And there were photos of the driveway from another store operated by the same defendant, and that driveway had markings that the plaintiff alleged should have been present at the driveway where this incident occurred. And so plaintiff's counsel argued that the jury should put more than 50% of the responsibility on this food or the supermarket. And then the defendant, the food town, they denied any responsibility for the incident. And they pointed out that plaintiff's blood alcohol level was high. It was like 0.26. at the hospital, and the plaintiff said that she only had a couple of drinks. So basically the injury was that she was taken to the emergency room and she had a comminuted proximal fracture of the left tibia and a bimalleolar fracture. So comminuted means it's broken into pieces. It's a more serious fracture. She was hospitalized for 3 days and she underwent open reduction internal fixation surgery, which is the type of surgery we just talked about. And then it left a scar, physical therapy. So what happened in this case was that the jury rendered a defense verdict. The jury specifically found negligence and comparative responsibility of 90% on the driver and 10% on the plaintiff, and did not find any negligence of the supermarket or the parking lot. So it was the driver and the plaintiff, mostly the driver who hit her, but also the plaintiff, I guess, for maybe being drunk. The jury determined that the damages actually totaled, since they gave percentages, right, to the plaintiff and to this other driver, they could determine damages. They determined damages totaled $71,000. $11,000 for past physical pain and mental anguish, $15,000 for future pain and anguish, and $30,000 for past physical impairment and $15,000 for past disfigurement. So actually like a pretty bad verdict for the plaintiff, I guess. I'm not sure if she was suing the other driver, if she already settled with the other driver. Because the way that the case was worded, it seemed like she was suing this food company, this food town. Yeah, I think the only lawyer in the case is for the food town. So maybe whatever happened with the driver was already settled before. So I'm not sure exactly how the details of that, but so that's the first case. Here's a case out of Michigan, and this case happened in June of 2024. And what happened here was that on October 31st of 2021, the plaintiff, who was a lady, 66 years old, retired, was driving on the 24-mile road and approaching the intersection with another road. And so the EMT was driving an ambulance northbound and with lights and sirens and responding to an emergency call. So what happened was that the EMT drove through a red light just as the plaintiff entered the intersection on a green light, and the two vehicles collided. And so now plaintiff's attorney did an interesting thing, because, these cases are a little difficult because if you have, lights and sirens on, you're allowed to run a red light, but you have to be careful. You can't just close your eyes and run a red light. You have to be careful. See, it's like with great power comes great responsibility. Because they give you the power to run a red light, they expect you to be very careful and very safe. So the plaintiff's attorney actually admitted that this ambulance EMT driver had the right to drive through a red light, but he maintained that he had to do so safely. And so the plaintiff's counsel argued that both industry standards and they had training materials for that company called MedStar required this driver to stop at the red light and make sure traffic was clear before entering the intersection. And he further argued that this EMT driver was wearing sunglasses at the time of the accident, and that the sunglasses came with a manufacturer's warning that stated that they can reduce peripheral vision and should not be worn while driving. And so plaintiff's counsel noted that the EMT driver's employer issued him a corrective action following the incident. And the defense said that the plaintiff was fully at fault for the accident because she failed to appreciate the approaching ambulance. And according to defense counsel, while the plaintiff admitted she did not see or hear the ambulance, she did not dispute that the ambulance had its lights and sirens activated. And the defense also noted that all the other traffic in this intersection stopped for the ambulance. And so that's the liability. Now, with respect to the damages, what happened was she had a right distal radius fracture, a right proximal humeral fracture, right trimalleolar fracture, left rotator cuff tear, left intertrochanteric. It's hard to say. Intertrochanteric, I think that's the hip, I believe, fracture with a varus deformity. And she additionally sustained patella and tibial plateau fractures to her right knee. And she claimed a subcutaneous contusion and gluteus medius hematoma. So she had a lot of injuries. She actually also had this open reduction internal fixation surgery on her left hip, right shoulder, and right ankle. And she required a total right knee replacement. So she had a lot of injuries. She had PTSD, depression, psychological counseling. And she sought recovery of past and future medical expenses and damages for past and future pain and suffering. Her husband had a derivative claim for past and future lost services and past and future loss of society, companionship, and sexual relationship. And the plaintiff's attorney asked the jury to award about $20 million. So it was a big case. And so the jury determined that the EMT driver, the defendant, was negligent and that the ambulance negligently trained and supervised him. And they concluded that the plaintiff was negligent as well, but the jury assigned 10% of fault to the plaintiff, 50% to the ambulance driver, and 40% to the ambulance company. So actually, it was a good verdict. And the verdict itself, the verdict was $373,000 for past medical costs, $4 million for past pain and suffering, $950,000 for future medical expenses, and $950,000 for future pain and suffering until the year 2042. And so the total verdict was $6,273,232.89. So pretty good result. And then for the husband, they gave $250,000, $125 for past and $125 for future, or for the loss of society, companionship, consortium, and attendant care. Now, the trial lasted 2 weeks. The demand to settle was $1.9 million, and the offer was $250,000. The jury was 4 men and 4 women. And yeah, so that's pretty much the case. So not a bad result there. I mean, $6 million, that's a nice result for that. And that was actually a good job by the plaintiff's attorney to convince them that it was, mostly the fault of the defendant, of the ambulance driver, because yeah, you have licensed sirens, you could be looking, you could see everyone stopped, I'm going to go through. If one person doesn't see you or for whatever reason, so that was a good job by the plaintiff's attorney. And actually, I know one of the attorneys that tried the case for the plaintiff. I see there's 2 attorneys listed. I know one of them. We actually go to some CLEs together. So okay, now I see why. I know that he's a good lawyer. He's a very skilled lawyer. So that's a great job. I have to ask him about this case next time I see him and get a little more info. And let me see. The next case. Here's a case out of New York. This is Kings County, which is Brooklyn. And what happened here, this was decided May 23rd of 2024. The plaintiff was a 47-year-old male. And also, I know the plaintiff's attorney on this one. Also see him and chatted with him a few times. He's a good attorney. So what happened here is that in January of 2019, the plaintiff, a 47-year-old store manager, entered the lower level of a building in the Sunset Park area of Brooklyn to attend a baby shower. And as he was walking in the basement, he slipped and fell, twisting his ankle. So he sued the owner of the building, alleging negligence, failure to repair, maintain, and the presence of what's known as a dangerous condition, something unsafe. So the matter proceeded to a bifurcated trial. The plaintiff claimed he slipped and fell on water that was leaking from the ceiling. Plaintiff's counsel contended it was discovered that there was a recurring leaking condition in the area where he fell, and the leaking condition had been there for some time. In addition, an independent witness testified that they had observed the leak on prior occasions dating months before this fall. And the plaintiff's attorney noted that a witness for the defense, the building repair person, admitted there were prior leaks in the subject basement but claimed the leaks were repaired. And the witness also testified that when the space was rented out, the building would provide a person to monitor for leaks. The witness further admitted that on the date of the incident, the building failed to provide someone to monitor for leaks. So the defense counsel argued that the owners of the building were unaware of any leaks and they were not responsible for the subject incidents because of the lack of being notified, lack of notice. And so the injury was a trimalleolar fracture of the right ankle, as well as a ligament disruption in the right ankle, fracture of the medial dome of the right talus, and an open reduction internal fixation with implantation of plates and screws. The surgery was performed. He then had to do a second right ankle surgery in 2022. The first surgery was in 2019. The second surgery was in 2022. And he underwent 9 weeks of physical therapy in total after the surgeries. And the hardware implanted from his first surgery became painful and symptomatic, requiring the need for subsequent surgery. And then the second surgery included a debridement of chondral injuries in the areas of the original fractures, and there was a lysis of adhesions within the ankle, which had formed as the ankle was healing from the initial surgery. The plaintiff's counsel argued that the plaintiff's ankle was observed to have traumatically induced osteoarthritis and a decreased range of motion. But despite his limitations, he was able to return to work after some time off, and he claimed he would have needed a future ankle fusion because of the severe degree of post-traumatic arthritis. And so the verdict. So after the liability, remember this is bifurcated, so that means there is one trial on who's at fault, liability, and then there's another trial on damages. So after the liability phase of the trial, the jury found that the owner of the building, the defendant, was negligent for causing the recurrent water condition, and that the negligence of the defendant was a substantial factor in causing the incident. The jury also found that plaintiff was negligent, but determined that plaintiff's negligence was not a factor in the happening of the incident. And while the jury was deliberating, the defendant raised its pretrial offer from $210,000 to $450,000. However, the plaintiff rejected the offer on the record. And after the jury's verdict on liability, plaintiff's counsel delivered a bad faith letter asking for an immediate tender of the full insurance policy amount available, which was $1 million. The next morning, the parties resolved the matter before the judge. Prior to the start of the damages trial, the insurer for the defendant agreed to pay $990,000 to settle the case. So they had $1 million policy. You see, during the trial, showing them that they're to blame, that they're at fault, and then they almost, I don't know, they kept 10,000, but they almost tendered it. They gave up most of the money, almost all of it. So it was a 3-day trial, 3-hour jury deliberation, 6-0 jury vote. The jury was 4 men, 2 women, and it was a Brooklyn trial. Here's another one in New York. This one's in upstate in Oneida County. This one happened in May of 24. It was a lady who was 38 years old. On January 13th of 2023, this lady, the plaintiff, a shift manager at a fast food restaurant, was outside a coworker's home, and she attempted to walk down the exterior staircase, and she fell down the stairs and suffered ankle injuries. So she sued the property owner, and she alleged they were negligent and had a dangerous condition. And she said the staircase's handrail was not properly secured to the ground, and that after she grabbed the handrail, it swung outward, then inward, causing her to fall. Court records showed that the owner of the property had her brother-in-law repair the handrail, but that he was not a licensed contractor, and that the owner failed to inspect the staircase to ensure it was properly repaired. And so the injury was a trimalleolar fracture, and a week after the fall, there was an open reduction internal fixation with 7 months of physical therapy. And so this case actually ended up settling, and it settled for $328,000 out of the $1 million policy. So not a bad settlement. I mean, not huge, but, you know, I guess it's not terrible either. It's some money, and it's upstate Oneida. So I guess upstate is a little bit more conservative. Let's see what other cases we have here. I might skip over a few if there's anything. I see another one here out of Queens. There was a defense verdict. Doesn't seem. Here's an interesting one. This is an unsafe packing of steel beams. So what happened here, this is a federal court case. What happened here was that on November 24th of 2020, the plaintiff, who was 25 years old and a steel worker, was unloading a large delivery of steel beams at his place of employment. A certified steel employee had loaded the steel onto the flatbed trailer. And so during the unloading process, a 9,000-pound stack of beams fell from the trailer and landed on the plaintiff, who was standing next to the trailer. And so they claimed that injuries to his pelvis, back, leg, ankle, abdomen, ribs, I mean, really bad injuries. Now, it wasn't just the ankle, but it was, well, one of the injuries. The plaintiff argued that they failed to stack the beams in an interlocking manner, and this made the beams unstable and caused them to fall. And also that the steel company negligently trained and retained the employee who loaded the steel. And yeah, so that's pretty much, and the injury was, in terms of the ankle, there was a right tibia and fibula fracture with non-union. The tibial shaft fracture was displaced and comminuted, and there was a closed and displaced bimalleolar fracture of the left ankle. Now, there were other injuries too. There was like transverse process fractures on the T-spine from T9 down to like L5, and pelvic fractures, non-union, real serious injuries. And this was in federal court. And what happened was that during the trial, the parties negotiated a settlement, and it was for $7 million. So there wasn't actually a trial. It was right before the trial, they settled it. So pretty good. It's a pretty good settlement. Here's another case out of Texas, Harris County, which is Houston area. What happened here was, it happened in January of 2024, that the trial did. And back in March of 2018, the plaintiff, a 70-year-old who was a retiree, was at the Houston Aquarium with her 7-year-old granddaughter. And she stumbled and fell on a rowboat replica in a dark, crowded corridor and broke her ankle. And so the injury was a bimalleolar ankle fracture and dislocation with a foot drop, which her orthopedic surgeon also attributed to the incident. Yeah, so pretty serious injuries. and there was surgery, and then there was this foot drop, which is a serious injury. And so this case, the verdict was only against this aquarium. I think there was some other defendant, and then the total verdict was $2,825,000. So pretty good, pretty substantial verdict. And the big part of the verdict was $1,500,000 for past physical pain and $500,000 for future physical pain. So that's $2 million right there. And then it was like $100,000 for past impairment, $100,000 for future impairment, $100,000 for past disfigurement, $150,000 for future disfigurement, and then $250,000 for past mental anguish and $125,000 for future mental anguish. So altogether, $2.8 million. It took 2 days, the trial. The jury deliberated for 2 hours. The jury vote was 10-2, and there were 3 men and 9 women on the jury. And you see what other cases. This is organized, like I said, from most recent going back, but you see what these verdicts. Here's a case out of Michigan. This was a pool hall that failed to apply salt to an icy parking lot. And so someone fell, had this ankle fracture. And I'll give you the short version. The verdict was for $378,000 in this case. So yeah, it's pretty typical what you see. A lot of these settlements will be like $300,000-$400,000. If it's something like you could show something more, like a bigger injury, you could get into the millions, like we've seen with some of these cases. Here's a case out of New York. This was also Brooklyn, Kings. What happened here, this was a case, it happened the trial happened in September of 2023, so about a year ago, a little more than a year ago. And the incident happened in September of 2019. The plaintiff was a 62-year-old unemployed lady. She was descending the interior stairs of her Brooklyn apartment when she lost her balance and fell forward. And she sued the owner and the managing agent, and she claimed the defendants were liable for a dangerous condition. And so what happened here was that her left foot contacted a chipped tread, causing her to slip, miss the last step, and fall to the ground. And the defect had been present for at least 9 years and had been in the same condition for at least 5 years. And they claimed the 2 handrails were too short and inoperable. And the defense argued that the chip in the subject staircase did not cause the plaintiff to lose her balance and fall. And they also argued that the plaintiff simply misstepped and caused her own accident. The trial was bifurcated. Damages were not before the court. Prior to the liability verdict, the parties negotiated a high-low stipulation and determined that the plaintiff's damages could not exceed $3 million. So high-low basically means that you get something on the low. If you get a defense verdict of 0, you don't get 0, you get something on the low. I don't know what it was here, but if you get like 10 million or whatever, you don't get that either. You get a high of 3 million in this case, right? So you could negotiate your own parameters. So if they give you 0, you get, let's say, 200,000, something to protect you. But if you hit them for like 10 million, well, you don't get 10 million, you get like 3 million or whatever you negotiate. So the injury was a displaced trimalleolar fracture and dislocation of the left ankle. There was a Jones fracture of the right fifth metatarsal, and her injuries caused post-traumatic ankle arthritis and left dropped foot. So again, dropped foot, that's a serious injury. We could do another video just on dropped foot. That's really serious. Now, she had an open reduction internal fixation surgery for her ankle, and she did physical therapy. And she needed future epidural and facet injections, along with more doctor's appointments, imaging studies, physical therapy, medications, radiofrequency ablations, and home health care. And the plaintiff's counsel claimed $2,728,484 just in future medical expenses alone. And that's what I've been saying, right? In a lot of my videos and a lot of the lives, I'm saying you can make these cases a lot bigger if you really get the right doctor to talk about all the future medical costs. So this lady was, I think, in her 60s, right? 62, and she had almost 3 million just in future medical expenses. So this was really built up in a smart way. And I know the lawyer who handled this case as well. He's a good trial lawyer. I've met him at some, he's here in New York. This is a New York case, but I've met him at a few functions, chatted with him a few times. I see him in court sometimes when I'm picking a jury on my trial. He's there. He's a good lawyer. I see he used a life care planner, an economist. He used an orthopedic surgeon. He used actually 2 economists. I wonder why. Maybe one for the lost wages or one for the medical bills. I'm not sure why they have 2 listed here. Maybe that was a backup in case one was unavailable. And he had an engineer too for the liability to show the fault. But so anyway, what happened here was that the jury determined that the defendants were fully liable for the accident, and pursuant to the high-low agreement, the plaintiff recovered $3 million. So that's pretty good, the $3 million. The trial took 7 days. The jury deliberated for 2.5 hours. The jury vote was 6-0. And yeah, it doesn't actually say what the jury awarded in terms of the verdict. $3 million, but that was the high. So I guess they awarded more. They must have awarded more than $3 million, right? If that was the high. Or maybe, you know what they might have done, because it says the damages were not even before the jury. This was just a liability trial. So maybe what they did was they said, look, if we find that you're 100% liable, the defendant, 100%, you get $3 million, right? But if we find 50-50, okay, then you get like, say, $1 million. And if you find like, the plaintiff is 100% at fault and the defendant's 0% at fault, then you get like 100,000 or something on the low. According to the high-low, people do that too. You do the high-low so you don't have to do damages. And the amount depends on the liability verdict, right? The percentage, because it could be anything. It could be like 0, it could be 50, it could be 72, right? It could be anything. So since they got 100% of liability against the defendant, 0% fault to the plaintiff, then of course she's going to get the high, which is the $3 million. So that's a smart thing to do sometimes. Let me see, maybe I can do one more case. There's a few, here's a defense verdict out of patient's hospital fall due to her own negligence. This was out of Philadelphia. Here's one out of Florida. Yeah, let's do this one. This seems like an interesting case. What happened here was that she was 47. She suffered an injury to her ankle at an IHOP. And this was a 5-day trial, 3 hours of deliberations. And it happened in June of 21. When she was leaving the IHOP restaurant, she slipped and fell on a worn, slippery step outside the exit. And then the step, which measured about 6 inches deep, violated building codes, because the step has to be at least 10 inches deep. And so the defendant refused to offer more than $100,000 to settle the case. The plaintiff was an Uber Eats driver, and she said that she was a single mom. She wasn't able to continue working. She had to find alternative care for her 2 children, such as transportation to school. So it sounds like they had a nice human story, like a nice biography to tell. And she had severe limitations. And her injury was, let's see. Yeah, her injury, she had pretty serious injuries. The way this is written up is a little different. They have all these quotes, almost like a news article, so they don't have the injuries listed here. But she had 2 surgeries, it says. Yeah, it doesn't really have it. I think news, it has a quotes of people talking. It doesn't have the specifics about the injury. But anyway, the jury determined and awarded her $8,299,916. And this was in Florida. And there was $5 million for past pain and suffering, $3 million for future pain and suffering, and then the rest for medical costs. It was a 4-day trial, 3.5 hours of deliberations. And this was in Broward County, Florida. So pretty good case there. Good one to end on. $8 million. Okay. All right. So these were some ankle and bimalleolar, trimalleolar fracture cases. We could do a few more. Let us know what videos you want to see. We could do a few more. We could do, maybe a type of injury with a certain type of incident, like trucking accidents that result in a certain injury. That way you get more specific and you can kind of do a comprehensive coverage of all or most of the cases that are out there. Okay, everyone, please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best. Bye-bye.